And I also do with fasting. This morning, I started that
Yeah.
Pasa a casa.
No, you started good game. Like, yeah, they've just got the excavated. So that's empty and next time it's different. Yeah, it's adding capacity and having the measure. Now we
Case number 2361/2024, Richard Fisher's Primary Cooperative into others, and the Director General Department of Mineral and Petroleum Resources and Food.
Great clear support by Lady for the applicants to together with Blomkamp as before.
Thank you, Mr. Hakan.
We have on behalf of the first and second respondent together with Ms. Ikar.
Thank you, Secretary.
Lady as before, third respondent with learned friends, Schildenes and Sarkas.
Thank you, Mr. Loxton. Mr. Loxton, we are ready to roll.
Right. I will try and roll.
Yeah, the petroleum sector is known for huge economic benefits. And at the same time, there are environmental risks. You heard yesterday from Mr. Hatton.
Yes, I'm
There
going to
is
try and
some review grounds, a lot of them, but 4 are being proceeded with
Yeah.
right now.
only 4 pursued in the heads of argument.
Yes.
I think the first round of review is actually an amalgamation of the first, second grounds in the founding papers. What I intend to do is to examine the relevant legislation,
Okay.
which is NEMA ICMA Regulation 18 and Appendix 3.
Mm-hmm.
And the purpose of doing that is the following. First of all, to demonstrate that the distinction between exploration and production is maintained throughout those provisions. There's a line in which authorization is required for a listed activity, and there's a strict division. Then to demonstrate that by complying with NEMA, the Total in fact complied with ICMA, and the minister, in considering what had been placed before her,
Whose cell phone is that?
I'm one of those.
Okay, Mr.
I
Dufu.
forgot to switch.
It happens to the best of us at times.
what I'm going to hope to demonstrate is that the scope of NEMA is such that in practical terms, compliance with NEMA involves compliance with ICMA,
Yeah.
and that the applicants have not shown that there is any requirement of ICMA which was not met in the course of complying with NEMA. They haven't said, for example, well, you were supposed to have done X, which is what ICMA requires. You didn't do X, and the consequence is Y.
Yeah.
Then what I also hope to demonstrate is that the reliance, that the argument that you must have regard to the environmental impact of the production phase, and it's not even really the production phase, it's the post-production phase that would give rise to the greenhouse gases. In other words, it's the burning of the fuel, it's the combustion of the fuel, which would give rise to that. That argument depends entirely on an argument that you can cross the boundary between one listed activity and another. You can go from exploration to production, and then you can say when you are seeking authorization for exploration, you must satisfy the requirements which really relate to production. And in the Durban South and Earthlight Africa cases, on which reliance is placed, there you had direct effect on the environment. You had direct effect on greenhouse gases. They are not comparable to the present case at all. And then in Green Connection, where there was a statement that exploration and production are intertwined, we say with respect that that is incorrect. They're not intertwined. The fact that one must precede the other, you can't have production unless you've gone through exploration, doesn't mean that when you look at exploration, you must have regard to the effects of production. And by production, I mean production and what follows production. Because production itself, as I said, is not really going to contribute to greenhouse gases. Now, there was an interesting difficulty which my learned friend for the applicants confronted, and it was this. The argument is not that you must carry out the kind of exercise that you would need to carry out if you were applying for an authorization for production. He says, no, we don't expect you to go to that extent. But the minister ought to have had a kind of general regard to the effects of production. Now, that's an untenable argument because you're creating a gray area where the decision maker would never be able to tell what elements of production or post-production should be taken into account when dealing with the listed activity of exploration. And so it demonstrates quite neatly the problem of regarding the two listed activities as being intertwined. Because you now are in an area where it's almost impossible to say, where do you stop? And let's look at the reverse side of that. Let's assume the decision maker refuses an application for an exploration right on the basis that if the exploration leads to the discovery of commercially exploitable gas or oil reserves, the extent of which and the nature of which is unknown and the location of which is unknown, that may possibly lead to the emission of greenhouse gases, which may possibly affect climate change. And he refuses, or she refuses. The review would be obvious. You've taken into account things for one listed activity which don't belong there. So you've crossed the boundary and you've refused an application for exploration right by looking at something which has not been applied for yet. So I think from the bench came and let me deal with, in this context, with asymmetry as well. When we look at need and desire, and I'll come back to need and desire, you again crossing the boundary. So the whole argument on climate change, the whole argument on need and desire, that all involves crossing the boundary between one listed activity and another. And a remark from the bench was, well, where I say to you there's a need and a desirability to explore for gas and for oil because a finding of sufficient commercially exploitable quantities of gas and oil means that the country will be able to satisfy, or at least partially satisfy, its energy requirements. And therefore it's needed. The argument is, well, you see, you've taken into account the advantages of finding something like that, but you haven't taken into the disadvantages. And the remark from the bench was, well, the problem with looking at disadvantages is you're in a notional field. You can't measure it at all. What we know is it's a good thing to know about it. So when you look at the minister's reasons in the appeal decision, And when you look at the answering affidavit put up by Total,
Clean cut.
you will see that it's very explicitly set out there. Why is it that you need this knowledge? So let's stop there for one moment. An absence of knowledge is ignorance. Ignorance can never be the basis for sensible planning. So when people like Mr. Trollope and some of the other experts for the applicants say, you shouldn't look for this. You should simply import. Import the gas. Let somebody else develop the resources. And then you can import it, liquefied natural gas, and then that is sufficient. So you're then saying to government, don't plan. Just assume that all you will ever do is import gas or oil from other countries. Let other countries develop their resources. But for South Africa, no. Let Namibia develop their resources. Let Angola develop their resources. We will simply look the other way. So you can see that the immediate problem with that approach is that ignorance has no advantage whatsoever.
So even if those resources have been imported, are they not going to result into a greenhouse gas emissions?
Yeah. So now,
Is the problem mitigated? The problem still going to remain the same?
so the difficulty is that, yes, you somewhere it's going to be used.
It's
So
going
as
to be
soon
used,
as you
yeah.
as soon as you realize that it's not actually the production, but the combustion of the product, well, our roads produce greenhouse gases.
Yeah.
Cars produce greenhouse gases.
It's
Planes
what we produce all of
greenhouse
us to be here this morning.
whether we
Yeah.
and in fact it's worse to import it because if you're going to use liquefied natural gas, it will be liquefied on some distant shore, put on a ship to sail across the seas, come to South Africa. South Africa, it will be gasified so that it can be used, or if it's oil, it will be either refined there or refined here and being used. So you've now got that carbon footprint. Instead of it being here, you've got that carbon footprint being created across the oceans. So there's simply no advantage there. So as soon as you realize that the Act, NEMA, Regulation 18, Appendix 3, are listed activity specific. That's the design of it. The MPRDA is listed activity specific. As soon as you keep to your lane, you do not get into all of these difficulties about the need and desirability having to include consideration of deposits you haven't yet found, of climate change arising from the utilization of gas or oil, which you haven't found and you know nothing about. That leads you, that road leads you into these imponderables. And there you get, if you have a look at the opinions put together by the applicants, you can immediately see the problem. The learned friend for the state said, well, this is a review dressed up as an appeal. And I'd like to just take that further for the moment, because there are two rules which make reviews governable, adjudicable. Those two rules are Pascal Evans number one. And number two, the court is not concerned with the determination of who is right. It's concerned with procedure.
Yeah.
And so right throughout my learned friends' heads of argument and their papers, you will see frequently that this expert of theirs should be preferred to that expert of Total's. That, in fact, the court should accept the opinion which is refuted by Total, that this process is better than that process. And for two reasons, the applicants can't go there. The one is Pascon Evans. It is denied. The second is it's an invitation to the court to find that a particular opinion is wrong.
Yeah.
And that's not the job of the court. There are statements in the heads of argument and in the papers by the applicants that something is an unreasonable conclusion. But that is not a Pudger test. In order to get there, you've got to demonstrate that no reasonable person in that position could have come to that conclusion, and they can't get there. So, with that introduction, if I just may take the court through, and I'll be short because the court's already looked at it, take the court through some of the provisions of NEMA to demonstrate the approach in NEMA and the fact that what is encompassed in NEMA includes all the considerations which would be encompassed by ICMA. The first aspect of, sorry.
Just for context for me, the applicant's intention is that under the need and desirability should have been spaced, I think basically over the life cycle. Are you able to just tell me what the life cycle?
So now that's exactly the point. If you're going to change lanes, if you're going to go from one listed activity being exploration to another listed activity being production, then your life cycle is from exploration all the way through to production and post-production, which is the utilization of the oil or gas. If you stay faithful to the legislation, then the life cycle is the life cycle of the listed activity, which is the exploration. So it's exploration from beginning to end. And when you go for your authorization, you'll say, I have met NEMA, I've met ICMA, I've met Regulation 18, and I've met Appendix 3 in relation to the whole life cycle. So that's in respect, an excellent example of how you can cross over and you can say, well, because it's a life cycle, it must include production and post-production. But in fact, it stops at the end of the listed activity. Going back now to NEMA, the starting point would be, well, what is the environment in NEMA that they're concerned with? And the environment is extremely widely stated. So it is the surroundings within which humans exist. Stop there for the moment. You can't imagine anything wider. That obviously includes the sea, the air, the land, the coast, and everything, including and are made up of land, water, and atmosphere, microorganisms, plant, animal life, any part of or combination of one and two, and the interrelationship among and between them, and the physical, chemical, aesthetic, and cultural properties and conditions of the foregoing that influence human health and well-being. So the environment is the widest possible expression of the scope of NEMA. Now, if one then turns in NEMA to 240.0, which is the criteria to be taken into account by competent authorities when considering applications, you again see in 240.01b, 24.01b, sorry, the relevant factors which must be included, and it's again the widest possible scope. In the principles which you've been taken to by, in fact, by the learned friend for the applicants, you'll see that in section 2.1, the principles set out in this section apply throughout the Republic to the actions of all organs of state that may significantly affect the environment and shall apply alongside all other appropriate and relevant considerations, including the state's responsibility to respect, protect, promote, and fulfill social and economic rights in Chapter 2 of the Constitution, and in particular, the basic needs of categories of personal disadvantage by unfair discrimination, and serve as a general framework within which environmental management and implementation plans must be formulated. So, if one goes through those principles, you can see that they are principles which apply equally under ICMA. Now, to then expand beyond, before I get to ICMA, to expand beyond the provisions of NEMA itself, Regulation 18, when considering an application, the competent authority must have regard to sections 24.0 and 24.4 of the Act, the need for the desirability of the undertaking of the proposed activities. That is vitally important. When they talk about desirability, and so this was the linchpin of the argument put forward by the applicants in this case, and the argument put forward by the applicants in to the other cases, including the case in which I think it's nearly the three of them, sustaining the wild coast is the same, and no, I think all of the cases had the same linchpin. But what they left out of the argument there was the fact that Regulation 18 requires the need and desirability of the undertaking of the proposed activity to be taken into account. The requirements of these regulations, any protocol of minimum information requirements relevant to the application as identified and gazetted by the Minister, government notice, or any relevant guideline published in terms of 24J of that. So Green Connection in particular, this was the basis upon which it was suggested that need and desirability must be need and desirability, including the production phase. And that is contrary to what Regulation 18 actually says. Regulation 18 says, stick to the listed activity. Then if you have a look, in addition to that, Appendix 3, again, this is relied on by the applicants. In this case, it's relied upon by the applicants in Green Connection. And Appendix 3, Item 2, is objective of the environmental impact assessment process. The objective of the environmental impact assessment process is to, through a consultative process, b, describe the need and desirability of the proposed activity, including the need and desirability of the activity in the context of the development footprint on the approved site as contemplated in the accepted scoping report, but again, limited to the proposed activity. So the approach that is adopted by the applicants, which is that this should be broadened, that somehow reading the legislation as a whole, they say it's quite evident that we must take into account the need and desirability of the production phase is simply not warranted by the language of the legislation. And if we follow the precepts in Indemani, and you'll see no real attempt at all by the applicants to come, and nor was there in Green Connection by the learned judge there, to come to terms with the explicit wording and limitations in the legislation in question. And Indemani would tell you, start with the language, look at it in context, look at its purpose, interpret it purposively. And the purpose of interpretation is to realize that the legislature has decided that there should be an approach which is, under the MPRDA, a distinction between exploration and production. Under NEMA, an intent to stay within a listed activity. And so once that is appreciated, and once the argument then that this must somehow be expanded into production and post-production falls by the wayside, then the entire argument about climate change falls to the wayside, because it's common cause that climate change will not be affected by the exploration activities. The entire argument that the minister erred because she did not have regard to the need and desirability for the utilization of the oil or gas that was discovered, and what falls to the wayside as well is the disadvantages, the environmental problems of utilizing any oil or gas find. That then would dispose of a number of the review grounds. And you then really left only with the review ground involving socioeconomic effects on small fishes. And there the difficulty is that the applicants simply haven't come to terms with what was before the minister, what was in the final ESR, the fact that they were catered for. And again, a distinction must be drawn between a review ground which said you have to take into account the socioeconomic effects on this population. And if you don't do that, then it may be reviewable. And an attempt at an appeal which says you didn't do enough.
Yeah.
We say you should have gone further than where you went. That is not where the court will intervene. The court will not say, we are dissatisfied with the extent of your efforts. They will look to say, this is what you had to do, you didn't do it, therefore you haven't met a legal precept. And so that then would dispose of that appeal ground. I'm going to come back to the Green Connection because I'd like to deal with it separately, because so much effort has been made to persuade this court that it is precedent, and as I understand it from the heads, binding on this court, and deal with the OCP and BOCP finding in Green Connection, and that's a second review ground. And the fundamental difficulty with that is this. There's a contradiction in the judgment. The court accepted, as did the applicants accept, that it is in fact not possible to determine what the effect will be of a well which suffers from defects, a blowout, or whatever it is, and how to deal with it until you get your environmental authorization so that you can go and see where you want to put the well, what you're going to get out of the ground, what the nature of is. Is it oil? Is it gas? What kind of gas? What kind of oil? So it's accepted that that can't be done. It's accepted that the OCP and BOCP cannot be completed until the EA is authorized. But then the court says, but you should have done it. It's incomplete. Because you didn't do it, your final SCA is incomplete, and the public was entitled to participate in determining, in having something to say about that particular plan. So that's illogical. The final SCA said itself that within 60 days, those plans must be produced. In Green Connection, there was a debate then about, well, but where is the provision for public participation? And the answer is, when those 60 days are up and the plans are produced, because it's a condition of the grant of the environmental authorization, you can then have a fight about that. You can have a fight about what the public participation should be, if any, because these are not mitigation measures. These are measures, it's a bit like firefighting. Mitigation is you've got fire-resistant material, you've got gas cylinders, you've got water hydrants, and then your firefighting plan. If this happens, what are you to do?
Yeah.
That is your OCP, that is your BOCP. It's my internal plan of how I'm going to deal with this. And that's why you can only formulate it finally once you've got your EA. So the Green Connection decision on that is we suggest unsustainable. Just before I go to the Green Connection itself, there are a couple of isolated points which are worth making. One of the criticisms of the minister is to say, well, you see, you imposed an onus which you shouldn't have imposed upon the applicants because you've said they have not persuaded you that the DG was wrong. And that's an unfair criticism because what the minister was dealing with was an appeal. So she's saying, you've appealed against a decision. You persuade me that the appeal should succeed. I'm not persuaded. There's nothing wrong with that. So when you look at it in its totality, if you keep to the legislation, if you keep in your lane, and if you keep to listed activity exploration, it really eviscerates this application. And what's left are the ICMA points, the OCP point, the fact that the allegation that you didn't consider small fishes. But when you see the way in which the applicants have constructed their case, the real heart of it is on need and desirability, climate change. They get there because they've crossed the line. If I may then, because so much attention has been paid to it, if I may then go simply to the Green Connection decision, which starts at 129 of the resource bundle. Your Ladyship very fairly sets out the background. So, for example, and the relevant legal principles. So, for example, at paragraph 80, court says, paragraph 81, the court said in Clearson CC, the Supreme Court of Appeal said, that's page 152, the role of a court is no more than to ensure that the decision maker has performed the function with which he was entrusted. That's your reviewed test. So that's fairly set out. And then on the first ground, failure to consider socioeconomic impacts, the court points out that in paragraph 87, that Total and the minister deny the applicant's charge in this regard, that they failed to take into account socioeconomic impacts, pointing out the applicants have provided an incomplete and inaccurate summary of the final EIR and SEI reports. They point in addition to the fisheries impact assessment report, which applicants have omitted to mention in this regard. It is common ground, however, that the final EIR accepted that although the risk of drought is small, the devastating nature of the impact required to be assessed. And that's the beginning of the development of the OCP, BOCP issue, which then Her Ladyship found that we ought to have nevertheless produced those particular plans. In paragraph 89, in contradiction to that, the FIA reports explains that there are limitations involved in the assessment of the impact of the blowout and the oil spill on the fishing industry, and that any assumptions would depend on at least 7 unknown factors, depending on the spread and concentration of the oil spill, namely oil type, characteristics of the reservoir, type of well blowout, well architecture, and spill duration, seasonality, and the well location. So there it's spelled out why you can't do what the minister was later on accused of failing to do, which is to take into account these very things. While I'm on that, perhaps it's appropriate then to deal with the use of the principle, precautionary principle. And the precautionary principle is written in, and fuel retailers is relied upon, but if you look at fuel retailers, it's very specific in requiring a balance between the need for economic development on the one hand and sound ecological principles and practices on the other. So it recognizes that development which the applicants do not always recognize. But importantly, what the applicants attempt to do with the precautionary principle is to undermine Plascon-Evans and to undermine the rule that the court does not get involved in appeal decisions, in deciding who's right and who's wrong. Because they say, well, we've got this expert says this, that expert says that, there's a contradiction. And you solve it not by applying Plascon-Evans, but by applying the precautionary principle to choose one expert over the other. And that's never been the role of the precautionary principle. When you read NEMA, the precautionary principle, which is set out in explicit terms, is you must always apply an approach which is cautious and careful in relation to environmental impacts. And that is why in the final ECI, the Total sets out the worst case scenario. That is how it copes with the precautionary principle. It says, well, look, here's a worst case scenario. If I may then just identify for the court some of the passages which are important in relation to identifying how the minister and Total went about identifying need and desirability in particular. I don't need to read it, but I'd like to identify it for court. Need and desirability is dealt with by Total in the answering affidavit at 1660 to 1665, and in the appeal decision at 875 to 878. And then I deal with the Trollope calculation. These are one of these isolated points. It's very difficult to understand why there is reliance on Mr. Trollope, because what happened was Mr. Trollope produced an affidavit in reply, not before the decision maker, which my learned friend read from to this court. But, as I say, in reply, and not before the decision maker. So you can't really criticize the decision maker for not taking him into account. But what's more, the calculation of the size of the gas fine that would be required in order to make its exploitation viable, his calculation was set out in the founding papers. That calculation was contradicted in its entirety by Total's experts. And there I would refer the court to the answering affidavit at 1676 and 1682. That refutation of the calculation is never really dealt with adequately in any event in reply.
So what were those page numbers?
That is 1676 to 1682. And then finally, there was a bit of a mystery about Professor Bracco. We understood from the heads of argument that the applicants were not going to rely on her calculations in respect of the depth of the well and its influence on the probability of a well failure or blowout. But there was a reference by my learned friend in his argument, despite the indication in their heads of argument that they would not rely on that evidence. But that's really immaterial because, again, what happens is there is a complete refutation of that particular ground in the by Total, and that you will find in the answering affidavit at 1733 to 1737. So in 1733 to 1737, Total's experts point out that there is no evidence to suggest that the depth of a well has anything to do with the stability of the well and the likelihood of a well blowout. There was no reply that we can find to that refutation in 1733 to 1737.
Sorry, I think your colleague also referred to Table 4, I think, and suggested that, in fact, the table relied on the basis for Bracco's opinion is not borne out.
No.
I think it is Table 4, I think.
Yes, I remember the table, and that is correct. So that argument, which is put forward rather confusingly, having said they won't rely on Professor Bracco, then they do rely on Professor Bracco, but Professor Bracco is actually wrong and is challenged, and there's no response to the challenge. One can safely ignore that. I have really dealt with the main points which I wish to deal with. If I may take a 5 minutes adjournment to see whether there are any specific instructions.
You were going to tell us about Green Connect.
Yes, so green connection, I've dealt with a number of, let me start off by dealing with green connection's place. The suggestion in the heads of argument is that it is binding precedent, and there are quite a few paragraphs in the heads of argument which suggest that we should follow precedent because otherwise the law is unpredictable. And the difficulty with that argument is, first of all, it's not precedent for this court. Second is that the learned judge herself, on the question of need and desirability of the production phase being taken into account, the learned judge granted leave to appeal on the basis that another court might find it differently. And there is, on the remaining grounds, an application for leave to appeal, and I understand at the moment that the Supreme Court of Appeal has now followed the approach adopted by the Constitutional Court, which is come and talk to us about both, about leave to appeal and about the merits. So just to summarize on green connection, so that this court would only look at green connection to see whether it finds the reasoning in that decision persuasive, as it would any other matter. And the different grounds are, first ground of appeal is at 153, it's paragraph 84 and following, which is failure to consider socioeconomic effects. And there the difficulty is that, as I've already indicated, what that deals with is the risk of a blowout. And the problem that is identified is at 87, where the learned judge says that Total points out that in addition to the fisheries impact assessment report, which the applicants have omitted to mention, it is common ground that the final EIR accepted that although the risk of blowout was small, the devastating nature of the impact required is to be assessed. The FIA report sets out the impact of normal operations, and then in 89, which we've already been to, it's an indication of why it's not possible to do more than has already been done in the final SEI report. Now, the difficulty with this first ground and the conclusion in 108, in the circumstances insofar as the final EIR failed to quantify the economic effects of unplanned events, it contravened section 24.4 and 24.0 of NEMA, in Appendix 3 of EIA regulations. And as a result, the decision of the DG and the minister should be set aside, is that the facts are different. So what the applicants do is that they take a finding in green connection, they apply it to these facts without demonstrating to this court that the facts in green connection are the same as the facts in this court. And what actually happens is that there's a learning curve. So you get green connection, you get the criticisms, those criticisms are responded to, there's a more nuanced or more complete approach in this matter, but they're adopting the findings on a factual basis from green connection to the facts of this case, and that's not permissible. The second ground of review is ICMA, and I've already dealt with that. That's at paragraph 109, page 161 and following. And the difficulty there is when the case is made that you have not referred to ICMA and you haven't identified how you dealt with ICMA, a point made in debate by this court is, well, given the scope of NEMA, what is it that you say in the assessment reports, the environmental reports that you put forward, that have been put forward, what is it that was missing in relation to the coastal impact on the coast? And that's not identified at all. They don't say, well, you see, if you look at it, you'll find that there's a specific requirement in relation to the community, and you didn't take community into account. The problem is that when you look at ICMA, it says it's the whole community. Now, as soon as it's the whole community, then NEMA does everything, because NEMA doesn't limit itself to any particular community. It's everybody affected by the listed activity.
So I think the complaint is that the minutes or the decision makers should have demonstrated that they conducted the assessment under a different ICMA-related framework.
Yes. Now, the assessments are only done through NEMA. ICMA does not have a provision which deals with assessments or decision making. So NEMA is the act which in terms of 24O makes provision for what is to be assessed. And in addition, Regulation 18 and Appendix 3, Sub 2, make provision for how the assessment is to be done. So what ICMA does, it gives you what should be taken into account, but it doesn't give you a process by which that should be done. And when you look at NEMA, it's certainly broad enough. So just have a look at, if one has a look at the ICMA requirements, do that for a moment. Yeah, here we are. You'll see that under Section 5 of ICMA, it says this act must, in relation to coastal management, be read, interpreted, and applied in conjunction with the National Environmental Management Act. The reason being that it is that act which gives you the process by which applications for authorization are to be dealt. It's true that NEMA has its own specified areas. For example, land which provides access to the sea is something specific to ICMA. But nevertheless, when you deal with whether or not there's a difficulty with access to the sea because of what your intended activity is, that is then dealt with through NEMA. Then the third ground, climate change, at 167. It's paragraph 130 and following. Third ground, failure to consider climate change. I've dealt with that. There's a reliance on Mr. Hill and Trollope. Of course, again, the facts are not the same, so his opinion is not necessarily the same, but the same principle, the same arguments are raised, broad arguments. And the whole climate change argument depends on crossing the line from one listed activity to another, and that is the very issue upon which Her Ladyship said another court might find differently. So the statement in paragraph 147 at 172, there is therefore no doubt that climate change impact assessment must form part of the assessment to be conducted and considered before the grant of an environmental authorization. We say that is an erroneous. This is 147 at page 172 of the paginated papers. So that conclusion that there is no doubt that climate change impact assessment must form part of the assessment to be conducted, we say, is erroneous. It relies principally on two decisions, South Durban and on EarthLife Africa, which involved activities which had a direct impact on the environment and a direct impact on greenhouse gases. And she mentions them in paragraph 148. It is correct that in the Wild Coast matter, there was a statement that climate change should be taken into account, but that is not a statement which, in that judgment, there's any reasoning provided. So the real reasoning provided is in EarthLife and in South Durban, and that is distinguishable. Her Ladyship's statement in paragraph 151, and I've dealt with this a little earlier, she says, whilst it is correct that the specific activity for which EA in this case is granted is exploration, not production, and that the former process will not always result in the latter process, the two processes are intertwined. We say that is an error. They're not intertwined. The one necessarily follows the other. The purpose of the one is to discover whether there should be production at some later stage. But if by intertwined it means that you can merge the two considerations, then that's not in accordance with the structure of the legislation. And the statement that there would, in paragraph 151, there would be no point in conducting an exploration activity unless an entity hoped to proceed to the next phase of production. It's correct. And it is not speculation to conclude that by the time such an entity applies for authorization to conduct the next phase, it is armed with information that places it at an advantage to proceed to the next phase. Also correct. But the conclusion from that therefore you should have regard to production, the effects of production on the environment when you're applying for exploration, that's incorrect. The one follows the other, they are not intertwined. Transboundary impacts don't apply. In this case, that's the fourth ground. And then ICMA we've already dealt with. We have produced a table which set out the relevant provisions of ICMA, and then a comparison with the relevant provisions of NEMA. Can I? Yeah. What I'm referring to is something different. There's a table that's set before the minister where the minister had regard to all the various provisions of Section 63, in which she set out what was required in terms of that section. And that is at page 1804 of the record. turn to that page, you'll see there's a consideration of all of those particular provisions.
Mr. Loxton, in your heads, you referred to the fact that the applicants relied on the grounds that it did not form part of the minister's appeal. Do you still pursue that line of argument?
Yes, it's big. One of the examples of that is the well depth.
Yeah,
That's a classic example. It was not before the minister.
yeah.
It was raised later. So to that extent, we certainly do. May I ask then for an adjournment? I want to see, there are a couple of loose threads that I want to see whether it's worth tying them together or whether I've dealt with them enough in the heads of argument. So
So we'll have to take an early adjournment.
yes, if I may, I'll be probably 5 minutes.
Let's take the whole 15 minutes
Thank you.
and come back at 11:18 for a chance for tea.
Yes, that's the problem, yes. No, it's not.
What you make with the amazing in the day, it was totally right. We did create our own table. We did our own components. They attached the elevation. So we also efficiently. So we attached it. These
Is that the
they, so this is straight from the red. So you name
Yes, Mr. Nixon.
Thank you. Very shortly. First of all, I'd like to correct something that I said about the well depth argument not being before the minister. It was, but Professor Bracker's report was not before the minister. That came later. Two other sources were relied upon. Then another correction is that I said that I think that the 60-day period in the final ECA in relation to BOCP and OCP would run from date of grant. It was actually 60 days prior to the commencement of the proposed drilling operations, and there I can refer the court to paragraphs 119 at page 74 of our heads, where we deal with exactly that topic, 119.1 to 119.3. And then finally, I referred to a table, and you'll find the reference to that table, which was compiled by the minister on the various provisions of section 63. So, sorry, compiled by the EAP, but placed before the minister and the DG. And there you will see the reference to that is page 1775 of the papers at paragraph 271, where we say the final SCA includes a table of the various requirements of section 63 and a summary of where it is addressed in the record. The applicant submitted in this section in the incomplete copy of the SCA attached to the founding affidavit as JWS4, and so the extract is attached at TAA1, and then TAA1 is in the papers at 1804 to 1805. And that's the table placed before the minister. Thank you. Those are my submissions. Unless the court has any questions.
Thank you, Mr. Loxton.
Thank you.
I think your references are much appreciated. Mr. Hathan.
Thank you, Madam.
You must do the damage control.
My lady, I thought it was all going swimmingly. I didn't see that it was any damage control was necessary.
To start with, is there any damage caused to your case?
My lady, I intend to focus on the two core issues in the matter and respond to the submissions, primarily in respect of the ICMA arguments and then the need and desirability.
Okay.
Now, the state in its submissions to this court, it took the court through the reasoning of the minister in some detail. It dealt with various passages in the record where it was contended that the minister had referred to ICMA and considered ICMA. We dealt with in some detail, but there was a glaring omission which I intend to take the court to in what the court was referred to. But the state submissions didn't refer the court to the Director General's findings, and the Director General's reasons for his decision are quite inconspicuously placed in the record. They form part of Annexure JSW8, and the reasoning is contained in paragraphs page numbers 593.
Just a second. You say it's JSW 8?
JSW8, and it's at pages, the reasons for the decision
Okay.
are contained at pages 593 to 596.
Okay.
So the reasons are very curt and abbreviated. And I wish to just highlight two aspects of the DG's reasons. Firstly, at page 593, he refers to the information presented to the department which was considered, and in paragraph 1.1, he sets out the chapter 5 of NEMA and the NEMA principles and the EIA regulations of 2014. But in the legislation that is referred to in paragraph 1 of the reasons, there's absolutely no reference to ICMA whatsoever. And then if one turns the page to page 594, at paragraph 3, under the key findings, again, one can read and reread that to one's heart's content, but one will find absolutely no reference to ICMA in the DG's reasons. Now, with regard to the minister's reasons, the court was taken through the minister's findings. They, in some detail in the state submissions, and the only pertinent aspect which reflects the reasoning of the minister is in response to another appeal. It's not the Natural Justice and the Green Connection appeal. They were the seventh appellants.
Yeah.
And the minister made some findings which the court was referred to at page 792 of the record in connection with the transboundary impacts. So if I submitted initially that the minister did not deal with ICMA and her reasons, then I must correct that, because she did in respect of one of the other appeals.
Okay.
But the pertinent parts of the appeal for the second and third applicants in this case comes at pages 887 to 888 of the record. And from 2.64.7 on page 887 to paragraph 2.649 on the following page, the minister summarizes the contentions of the two applicants in this matter. And then, the court was taken through those that summary yesterday. Then the TEEPSA's response and their submissions in respect of the two applicants' contentions is contained at pages 898 to 899. And the paragraph numbers are 2.65.17 to 2.65.19. And then at page 910, the minister summarizes the response of what she suggests is the competent authority. This is at paragraph 2.66.19. The applicant's case is that was actually a response drafted by PASA on supposedly in the name of the competent authority. Then the minister's evaluation of the contentions which have been summarized, the court has been taken to. It's contained in pages 911 to 913 of the record. So she set out the various contentions that she's got to deal with. And then from page 911 to 913, she deals with her evaluation of these submissions. And in what I can only suggest as a blunder on her part, she fails to deal with the ICMA requirements, the submissions that from the three various parties. She just doesn't, having summarized the various parties' contentions, in her evaluation of those contentions, she just doesn't deal with them. She doesn't evaluate them. She doesn't deal with ICMA whatsoever. So the reasons for decision are silent in respect of ICMA. And I can only assume that this is an oversight, but in our submission, the minister's decision cannot stand, and neither can that of the Director General, as a result, firstly, of the failure to take into account relevant circumstances, and yesterday, Milady, I took the court to the decision of the Eastern Cape full bench in sustaining the Wild Coast. And although that was distinguishable in that it did not pertain to an environmental impact assessment, and ICMA, section 63 of ICMA, which is only applicable to, environmental authorization. Section 63 is only applicable to environmental authorizations. But the Eastern Cape full bench found that the decision was reviewable on the grounds of the failure to comply with sections 12 and 21 of ICMA, failing to take the ICMA requirements into account because they confer a special legal status on the environment in question. And again, I don't want to repeat myself, but the finding of the Eastern Cape full bench in that regard was upheld in the unanimous decision, judgment of the Supreme Court of Appeal, authored by Justice Ponnen, where he found that a number of relevant factors were not considered, including the requirements of the ICMA, and which the court in Justice Ponnen's judgment stated creates specific measures for the protection of the coastal zone. So it creates measures that were not in existence prior to ICMA coming into effect. And
follow the argument. Are you saying the minister absolutely no regard for any of the ICMA considerations that we proposed in that regard, for notwithstanding the passages referred to from the CDP at some length, where the minister refers to those factors.
She summarizes them, but she doesn't evaluate them. She doesn't draw any conclusions. Her reasoning, the reasons for her decision are completely silent in respect of ICMA.
So the fact that she doesn't mention ICMA by name in the evaluation, does it necessarily follow that she therefore didn't take account of the factors which she's supposed to have had regard to, which, as your colleague Mr. Loxton submitted, are the factors that are largely set out in NEMA. As the third respondent pointed out, it is in NEMA that requires environmental authorization, not ICMA. ICMA doesn't tell you how to do it or what the procedure is. You have to go under NEMA. Yes, you must have regard for ICMA, but you go under NEMA. So essentially it's a NEMA evaluation which has regard for NEMA factors and any other factors that are in addition to the NEMA factors in ICMA. Now, where, other than the argument that it wasn't mentioned by name, where, with reference to the evaluation, where is there evidence that the minister failed to have regard for, in coming to the decision, for specific factors not mentioned by NEMA but required to be taken into account in ICMA?
Your Lordship, I'm going to respond in detail to the submissions presented by Mr. Loxton, and in particular, the submission that was advanced that ICMA does not apply to decision-making processes. We have differing submissions to advance in that regard. In response to your Lordship's question, there are two answers. Firstly, the absence of any reasoning in the evaluation of the minister's decision indicates that there, even though she might have read and summarized the contentions of the party, she didn't draw any conclusions concerning those reasons. And yesterday, we referred the court to the Constitutional Court. Apologies. We referred to the court to the judgment of Koyabi, and the test that we submit as applicable is that the reasons must convey why the decision maker thought the decision was justified. And our submission is that if one applies that test to both the Director General's decision and the Minister's decision, there is absolutely nothing to indicate the reasons why they thought that their decision was justified and that the ICMA requirements were satisfied. If I can now turn to the submission advanced on behalf of TEEPSA this morning. As I understood it, there were essentially three components to it. That firstly, compliance with NEMA would effectively amount to compliance with ICMA. The word substantial compliance were not used, but I understood it to amount to much the same thing. And secondly, that the applicants have failed to identify what was missing in the assessment conducted by the decision makers. And thirdly, that ICMA has no provisions that are applicable to decision-making processes. And if I can begin by addressing the third aspect of the submissions advanced by TEEPSA this morning, and begin with section 6 of ICMA. Section 6 deals with the interpretation and conflicts with other legislation. And section 6, perhaps to be fair, it's important to put section 6 in its context, and this court was referred to section 5 this morning, which says this act in relation to coastal management be read, interpreted, and applied in conjunction with the National Environmental Management Act. So that is the context in which it comes in. And section 6 states, if there is a conflict relating to coastal management between a section of this act and any other legislation existing when this act takes effect, the section of this act prevails. So in relation to coastal management, NEMA was pre-existing legislation when ICMA came into effect. So insofar as there are inconsistencies, ICMA prevails. And this reinforces our submission yesterday in relation to the principle of subsidiarity. The more concrete and detailed and lower level norm or legislation takes precedence over the higher level, more abstract regulation or norm. That is the starting point. Then section 12 is also of significance in relation to the decision-making processes. And section 12 deals with the state as public trustee of coastal public property. It states that the state, in its capacity as the public trustee of all coastal public property, must A, ensure that coastal public property is used, managed, protected, conserved, and enhanced in the interests of the whole community. If one is to try and argue that that doesn't encompass decision-making processes of the nature of the environmental authorization in question in the present matter, then one would have to fight with or contest the correctness of the SCA decision in sustaining the wild coast. In any event, in respect of environmental authorizations, section 63 of ICMA makes it quite clear that the factors specified in section 63 must be taken into account for purposes of a decision as to whether or not to grant an environmental authorization. The second aspect of the submissions advanced this morning was it was contended that the applicant had failed to identify what was missing in the evaluation that was conducted for purposes of NEMA. And in other words, what would have been different if this had been evaluated in terms of ICMA rather than through NEMA? And my lady, I wish to focus on 3 provisions within section 63, which in our submission, the decision makers were required to consider, to weigh, and which, on the evidence available, yet we infer that they failed to do so. The first provision is section 63(1)(c), which requires the decision maker to take into account whether coastal public property will be affected, and if so, the extent to which the proposed development or activity is consistent with the purpose for establishing and protecting those areas.
Can I engage you on that? On your argument, to answer that question in the regard for production, on your argument. On the respondent's argument, that is not the correct approach. The correct approach is a listed activity which pertains to exploration only, and it is only in relation to the activities pertaining to exploration and their possible effect on the coastal public property that one must look at this effect. Have I correctly?
No, with respect to our argument with regard to need and desirability is that for purposes of determining the need and desirability, one must go beyond the immediate impact of exploration and look at the project as a in a holistic sense as a whole.
Well, I'm asking.
Yeah. Well, section 63(1)(c) requires the decision maker to take into account whether the development or activity is consistent with the purpose for establishing and protecting those areas. And then one needs to answer that, one needs to have a look at the purpose, and the focus in our submissions is on coastal public property. And the purpose, the definition of coastal public property is provided in section 7 of NEMA. And it's a detailed compendium description in section 7, which includes coastal waters and the land beneath those waters. And the purpose of establishing coastal public property is set out in section 7A of ICMA.
If you don't answer the question of both, if you don't mind, could I just ascertain what is the correct question to ask in relation to 63(1)(c)? Can we read the section? It says, you must take into account all relevant factors, including whether the coastal public property, the coastal protection zone, or coastal access land will be affected, and if so, the extent to which the proposed development or activity, hence my question, is consistent with the purpose for establishing and protecting those areas. So the first question we must answer is, what is that activity need? Is it the exploration? That's what I'm asking. Is it exploration only? And sinking a well 180 kilometers off coast? Is it that activity and any potential blowout or oil spill? Or is it the whole coast production? Or it doesn't seem to me that that is what is envisaged. It must only be the activity relating to the sinking of wells for exploration. Can't be anything else.
Your Lordship, Justice Sher, I'm going to deal with the purpose, and then can I attempt to answer what is being put to me. But because the purpose.
Just before you proceed with your submissions, Mr. Houghton, I thought there was an independent environmental assessment report that was submitted to the DG and also that served before the minister. Was the coastal public property not taken into account in those reports?
There was a table that was part of, I think it was the final environmental and social impact assessment.
Yeah.
That included a table, which the court has been referred to.
Yes.
But that was not considered in the DG's reasons or in the minister's reasons. In fact,
But it served before them.
it served before them. So there's possibly an argument to be made that they took it into account, although they didn't tell us. But the difficulty for them is that that the test in Koyabi for giving adequate reasons for the decision is not satisfied.
What was the purpose of this whole oil modeling, the oil spill, the whole lot of evidence that they put before the decision makers about whether an oil spill would reach the coast and in damage to the coast? What is the point of all of that if it didn't impact on coastal public policy? That is not at all something that is taken into account. Why was all of that? And the different seasons and the currents and the tides and how that would affect whether the oil spill would reach the coast. But why was that there?
My Lord, sorry, I'm wanting to answer the first question that you put to me, and if I engage with that one, I'm going to lose the thread of my argument in relation to the first. Can I deal with the section 63 one question first, and then perhaps come back to that? So the purpose of coastal public property is set out in section 7A. And there are a number of, there are 5 purposes that are set out there. The ones that we wish to highlight are to protect sensitive coastal ecosystems, to secure the natural functioning of dynamic coastal processes, and to facilitate the achievement of any of the objects of the Act. And the objects of the Act are set out in section in section 2. And the object of the Act that is of particular relevance for this inquiry is section 2C, which is to preserve, protect, extend, and enhance, and I emphasize the word enhance, the status of coastal public property as being held in trust by the state on behalf of all South Africans, including future generations. So part of the object of the Act is to designate coastal public property as an area which is given enhanced protections. Those are greater protections than those provided for under pre-existing legislation before ICMA came into effect. And that would include the protections provided for in terms of NEMA. Now, if I can having laid the groundwork, if I can come back to what was put to me by His Lordship Justice Scher, and in my understanding of the applicant's case, and I'm not wanting to bind them in this regard because it's not something that I have clear instructions on, but in my understanding of their case, that the applicants contend that the need and desirability inquiry has a broader scope than the impact inquiries that are required to be assessed in terms of NEMA. So the need and desirability inquiry is the outlier, which requires consideration of the need and desirability of the project seen as in a holistic sense, whereas for the other inquiries, one is focusing on the impact of the activity for which an authorization is being requested. I hope that provides an answer to the question which was being put to me.
Okay, so thank you. So if I understand correctly, you agree that insofar as section 63(1)(c) is concerned, the reference to activity must only be in reference to exploration activity.
That is correct. That would follow.
I thought you were saying the reference to the entire project includes exploration and production, not only exploration.
That is for purposes of the need and desirability inquiry. One looks at the whole project.
What is the whole project, according to your?
Well, it would be the entire life cycle
cycle.
of the project, and the post-production, the drilling of the wells for production purposes, the post-production, and the carbon emissions that are generated as a result of that.
So why do you say this is not had regard? What would be the point of the BG or the minister engaging on these BOCPs and OSCPs, and the question of whether or not it is good enough to have these in principle and not in real concrete form? There was a whole debate about whether it's good enough to leave that for formulation closer to the time when you explore. What is the point of all of that if in the minds of all of those involved, including the decision maker, the question which they were wrestling with was, what if there is a blowout and there's an oil spill and it will go to the coast and damage the coast and marine life and sea life? What would be the point of all of these things? The oil spill modeling, all of that. Why was that even bothered with if you say none of this is taken into account?
My Lord, can I take the court through the two other aspects of Section 63, which
Just to
we
finish the
submit
argument.
should have been taken into account, which weren't, and then come back to address that question in the context of those further provisions. The second section in Section 63 which in our submission required consideration is Section 63H Roman 1, which required the decision maker to consider whether the development or activity and my Lord, I see that the wording there is actually broader than just the activity. It's the development or activity. So it perhaps is a basis for contending that the scope of the inquiry for ICMA is broader than simply the development. But I'm not in a position to advance any further submissions in that regard, but simply to note that. And Roman 1 is situated within coastal public property and is inconsistent with the objectives of conserving and enhancing coastal public property for the benefit of current and future generations. Again, the objective of enhancing coastal public property as an objective of ICMA is again highlighted there. And then in Romans 7, that's H Roman 7, the decision maker should consider whether the development or activity would be contrary to the interests of the whole community. Now, the court has already been taken to the definition of the interests of the whole community, and I'm not going to take the court back there. I just will summarize that there are three components to the interests of the whole community. And that is, firstly, to prioritize the interests in coastal public property of all those people in South Africa over the interests of a particular group or sector. So it states explicitly that priority must be given to the general public interest in coastal public property, rather than the interests of a particular sector. Oil or gas would be included in that. The second aspect of the interests of the whole community is that a long-term perspective is taken with a view to ensuring that future generations inherit coastal public property. And the third is that the interests of other living organisms be taken into account. Now, having laid the basis for the provisions that we submit should have been taken into account, to address the question now that is being put to me by the court, I have taken the court to 3. If I can just repeat them.
Or other organisms to be taken into account that in the coastal area. Yeah.
Yes, I have taken the court to 3 sections. The first is section 63(1)(c). The second is section 63(1)(h) Roman 1. And the third is section 63(h).
7.
Sorry, section 63(1)(h) Roman 7. And Lordship, Mr. Justice, sure, if I can now, having taken the court to those provisions, if I can now respond to the question that was put to me by the court, what would have been different? The answer is that the lens through which the decision maker should have analyzed and evaluated these considerations is different under ICMA to that provided for in terms of NEMA. Firstly, it requires an enhanced level of protection, a higher status for coastal public property. And secondly, there are considerations that have to be taken into account in terms of ICMA, which don't apply in terms of NEMA. And of particular importance in this regard is the concept of the interests of the whole community, which I'm belaboring the point, but it requires priority to be given to the interests of the general public, a long-term perspective, and also the impact of activities on other living organisms. So that would be the answer, that the prism, the lens in terms of which these considerations are evaluated in terms of ICMA differs in material respects from the NEMA lens. So it cannot be an answer, as was suggested on behalf of TEEPSA this morning, that the evaluation in terms of ICMA was redundant because it had all already been done in terms of
Mr. Hatham,
NEMA.
I'm struggling to understand your argument in as far as the interest of community is concerned. Remember, when the DG granted that authorization, a lot of interest groups stood up and filed an appeal to the minister. It was a lot of them, not only the 3 applicants that are before us today. So if you're saying the minister failed to take into consideration their interests, would that be correct? Because the minister in his or in her decision went and at length dealing with each and every organization's complaint. So for you to say they were not taken into account, I'm struggling to understand at what point did that happen? Because the decision is there. The minister went into subheadings dealing with each and every organization's complaint.
Haledi, if I can respond with a hypothetical, but assuming the minister was in a public meeting and issues were raised with her about the proposed exploration activities, she listened to them, and then she went away and made a decision and completely ignored them. The fact that she had heard them would be inconsequential for purposes of deciding. If she heard them and ignored them, it wouldn't be tenable for her to argue that they were taken into consideration. Consideration requires that they were considered, assessed, and evaluated, and that is what is lacking on the part of the DG and the minister. And in any event, even if I'm not correct on that, then the reasons that they furnished for their decisions
So you
were entirely
wanted
inadequate.
an all-encompassing reasons, so to say.
Well, there are two legs to the argument, my lady. The first is that consideration requires an evaluation and conclusions to be reached. And the second leg of the submission is that the reasons that are furnished for the decision must explain why it is justifiable.
Okay.
If I can move on to the second core component of the case, and that is the question of need and desirability. And this is it's not a usual situation, but the positions adopted by the state respondents and TEEPSA differed in important respects in this regard, so I intend to respond to them separately. And if I can begin with the state respondents. In response to a question from Her Ladyship Justice Mayosi, the state respondent's position, as I understood it, was that for purposes of the need and desirability of inquiry, one should take account of the benefits of the positive outcomes that would flow from the project. That is, in short, that is production and its consequences if production happens. While on the other hand, the negative consequences of production should be held over for consideration at the stage of application for an environmental authorization for production. In effect, it would, counsel for the state was contending for an asymmetrical inquiry into need and desirability.
But at this stage, neither the positive nor the negative is assessed before the minister in relation to productivity. Neither is assessed. So such positives are not really being assessed. They're being considered relative to policy documents and so on and so on. what would ultimately eventuate if something was found. So neither the positives nor the negatives really are being assessed because they're not the fourth things.
My lady, could I come back to what is being, because I'd respectfully would differ from what is being put to me, but I'm going to address that in response to the submissions that were advanced to the court this morning. So if I can come back to that shortly. And to come back to the state's position, we submit that this approach in support of a asymmetric inquiry into need and desirability is logically untenable and is inconsistent with the requirements of the need and desirability guidelines. I can begin by turning to the guidelines. They're to be found in the supplementary bundle of authorities that the applicants delivered to the court yesterday. And the important page to which the court is being referred is page 10 of those guidelines. And in the second paragraph, on page 10, the guidelines say that need and desirability are explained in terms of the general meaning of those concepts, and they interrelated. The two components collectively can be considered in an integrated and holistic manner. And then the last paragraph on that page, the last paragraph of Section 3 of the guidelines says, the consideration of need and desirability in EIA decision-making therefore requires consideration of the strategic context of the development proposal, along with broader societal needs and the public interest. That's an important sentence which we stress, that requires consideration of the strategic context. So that we submit clearly envisages going beyond bounds of the particular activity under consideration. And then if we skip a sentence, ultimately development must not exceed ecological limits in order to secure ecological integrity, while the proposed actions must be measured against the short-term and the long-term public interest in order to promote justifiable social and economic development. Again, the approach advocated in the guideline supports the integrated, holistic, long-term approach that I referred the court to yesterday in taking the court through the principles in NEMA. So our submission is that the guideline provides no support for the asymmetrical approach contended for by the state, and to the contrary, suggests the opposite. The two concepts are interrelated and must be considered holistically. At a conceptual level, what is being contended for by the state is problematic.
I'm looking at the second sentence. at page 10, in the last paragraph that you didn't read. It says the government decision makers, together with the environmental assessment practitioners and planners, are therefore accountable to the public and must serve their social, economic, and ecological needs equitably.
Yes.
So has this not happened in this case?
We would submit that it hasn't, my lady, because of the omission to take into account critically important considerations.
Okay.
My lady, if I can return to the concepts of need and desirability, if one has regard to them in the normal meaning of the words, as the guidelines tell us that we should, desirability cannot be assessed without a weighing up of both the positive and the negative impacts of an activity. So if you are going to argue that need and desirability is going to encompass the desirability of production, then it must follow, if you look at desirability, that you're going to have to determine whether it's desirable. If you're going to leave the negative consequences out of the equation, that is not an evaluation of desirability. To decide whether it is desirable, you've got to look at the positive benefits, you've got to look at the negative consequences, you weigh them up and you decide, yes, it's desirable, or no, it's not. But it's logically untenable to say that you can look at desirability without taking into account the negative consequences. And our submission is that as a matter of logic, the state's position is untenable. It's also this asymmetric inquiry that they've adopted. There's no support, as far as we have been able to establish in the regulations or the guidelines for such an asymmetric inquiry.
Yeah, I don't follow that. If you look at the regulations and you look at the act, it's quite clear that reference to activity, reference to the listed activity for which environmental authorization is sought. In other words, exploration, not anything beyond it. That's the first issue. Our second issue is, again, a matter of practicality. How and what do you then take into account? How do you then put an EA together, firstly? What do you put in the EA? And what was the decision maker have regard for? If you must go beyond exploration, you must go to production and combustion, because there you're only going to get to climate change. So what is it that, how is this ever going to be satisfied practically? How is it ever going to be done? And how is the decision maker going to make a meaningful decision? What must be before the decision maker?
My Lordship, just to show again, I'm not trying to avoid the question, but if I can address the contentions that were advanced by this morning, and then come back to what is being put to me by the court. My Lordship, Mr. Justice, sure, I'm told that the first question you put is addressed in our heads of argument from paragraph 109. I haven't looked at it, but...
The first question I put is based on what you just said. Earlier, you said nothing was said by your colleagues. They haven't counted your arguments. Without trying to summarize a long argument, you suggest that there is nothing concrete anywhere in the legislation. They haven't referred to anything that supports the contention that needing desirability must extend to be symmetric, must extend beyond exploration to everything that follows. And I'm saying to you that statement is wrong. They submit that there is a lot in the legislation, regulations, appendix, that suggests it's confined to exploration, not beyond.
I thought that I must have put my submission without clarity. What was being proposed was that there was nothing in the legislation or the guidelines which would provide support for an asymmetric inquiry. So if one has regard to need and desirability, one can look at the long-term benefits that would result from the project as a whole, but where one eliminates from the scope of that inquiry the negative consequences. So that was the limit of the submission.
You consider it only becomes asymmetric if you take and you add production in. If the inquiry is confined to the activity, if the assessment and authorization which is sought is confined to the activity, then it is the benefits and disadvantages of that activity, and that's all that needs to be taken into account. If it's properly taken into account, it's a symmetric evaluation as far as is required.
We accept that, and that was the argument that was the position that was advanced this morning, as I understood Mr. Loxton's submission, and that's what I intend to turn to now. So the argument was that one should, for purposes of the need and desirability inquiry, that one should keep to one's lane. What was being sought was an exploration environmental authorization. One looks simply at the advantages and the disadvantages of that activity. Well, that might be a more logically appealing argument than the asymmetric inquiry. It's actually not what happened in this matter. And if one turns to page 49 of the record and to have regard to the nature of the environmental impact assessment report that was presented and the conclusions that were reached in that regard, one will see this is not what happened in the present case. That at paragraph 158 of the founding affidavit, the environmental assessment practitioner indicates that the exploration activities are compatible with the triple bottom line required by NEMA, and makes the observation that the government has indicated there's a need for the country to reduce its reliance on coal-based electricity and committed to a just transition. Natural gas is included in the energy mix as a transition or bridge, and by determining the presence and extent of such resource, the sustainability of developing the petroleum sector within the country can be better considered.
So is that not strategic alignment that is called for in that?
Right. But if we can go on to consider what was what was said in respect of the need and desirability inquiry, and then the findings of the decision makers in that regard, then we can come back to address that. Then at paragraph 159, the applicant set out the conclusion to the need and desirability section, where it stated that it's acknowledged that the exploration would not result in the production of oil and gas, but rather the generation of information. And then in the following paragraph, the proposed exploration project will potentially lead to South Africa optimizing its own indigenous resources to provide its identified oil and gas needs until the 2050 deadline to achieve carbon neutrality, rather than having to mainly import as at present. So that's definitely factored in into the need and desirability assessment. And at paragraph 160, the applicants contend that the EAP construed the purpose of the exploration activities as being solely to that of exploration, while simultaneously citing the prospect of South Africa optimizing its own indigenous resources to provide identified oil and gas. And this reasoning was adopted by the DG and the Minister. Paragraph 162 sets out the paragraph in which the DG's conclusion on need and desirability was expressed. And the Minister provides more detail as is set out at paragraph 163. And the commitment to the just transition to net zero emissions by 2050 is relied upon, and South Africa's commitment to reducing its emissions is reflected in the NDP. And over the page, in the final paragraph quoted, I am satisfied that the criteria for need and desirability has been demonstrated by the applicant, in particular that the project accords with legislative requirements and government policies and plans, including the IRP 2019. IRP and the IEP recognize natural gas as a required source to produce electricity and direct thermal energy. It acknowledges its role in contributing and maintaining baseload electricity and peak load electricity, etc. It's clear if one has regard to the Minister's reasoning that the desirability of a successful production of oil or natural gas is an important component taken into account by her for purposes of her findings on need and desirability.
So, Ms. I want to block this issue. Again, I ask, is that not the minister or the decision maker demonstrating an appreciation of the strategic context in which this application for an exploration EA is being made, rather than it being an assessment of the productivity issues?
Yes, we're not contending that for a detailed assessment of the production activities. That would be premature at the stage of exploration. But the submission is simply this, that if one is going to have regard to the potential benefits of which would result from the production activities, then one cannot leave out of consideration, one is going to assess the desirability, the negative impacts of that. And it's not requiring, we wouldn't contend for speculation about the extent of the activities that would require, but what should have happened is that the applicant should have put forward what information was available to them concerning the possible or probable extent of the resource that would be available, the extent to which it would account for South Africa's energy needs, and also the environmental impacts of the exploitation of that resource. So it wouldn't be a detailed assessment as would be required if a production authorization was being applied for, but it would be an outline, preliminary assessment of what the likely or probable consequences would be of production. And we need to stress that we do not, it wouldn't be required of this court to make an assessment of the merits of whether or not a an environmental authorization was a need and it was desirable, but we would limit our submissions to saying that the decision makers failed to have regard to material considerations, and on that basis, the decisions are reviewable. On the basis that both decision makers failed to take into account material considerations. My lady, just one or two loose ends. At the time that we drafted the heads of argument, the judge president had not been approached for a full bench to hear this application. So the understanding upon which we drafted the heads, that the application would be heard by a single judge. A single judge would have been obliged to follow the precedent in the Green Connection case unless they were persuaded that it was clearly wrong.
That makes sense.
It was only after we submitted the heads of argument that the TEEPSA made a sudden application to the judge president for a full bench to hear the matter. One can speculate as to what their motivation was in that regard. And
We appreciate your honesty as far as that is concerned.
my lady, something was made of the Visagie judgment, which is in the supplementary bundle, and the fact that I didn't refer the court to the judgment.
Mm-hmm.
The reason why in my initial submissions that I didn't refer the court to the initial judgment was that the judgment that we had in mind was a judgment of Justice Williams sitting as a single judge who dealt with the question of the standing of a judgment which is being taken on appeal and has not been decided. And Justice Williams in her judgment found that it still stood, the ratio and the reasoning in the judgment still stood, unless of course it was overturned on appeal. And her judgment was taken on appeal, and the reason why I didn't refer, and that is the judgment that is contained in the supplementary bundle, which we had intended to rely on the Justice Williams judgment, the appeal judgment, which said that it found that the judgment or the reasoning of Justice Williams was persuasive, but there was no need for the appeal court to decide the question. It was the judgment that is included in the bundle, and that is the reference to Justice Williams' judgment is in paragraph 24 of that appeal judgment. It's at page 227 of the bundle. My lady, unless there's any further questions from the court, those are my submissions.
You have nothing to say about the fact that it was argued that this is a review addressed as an appeal.
My lady, I thought that my submissions in my initial submissions where I referred to the South Durban judgment and the fact that that said that an application for an environmental authorization in terms of NEMA, the criteria are so densely specified that one can review an authorization on the basis of whether or not it complies with those detailed requirements in NEMA and the normal considerations as to whether or not, the normal considerations with regard to an administrative discretion and the polycentric nature of that discretion are not applicable in the circumstances of NEMA. With regard to the TEEPSA submission this morning, and that saying that the decisive considerations of Plasmon Evans and the procedural issues. So our submission that overlooks that there are no bright lines between procedure and the substance. The requirements of reasonableness and rationality blur that line.
Okay.
And in any event, given the context of this and the detailed specifications for environmental authorizations, the issue before the court is squarely were the authorizations issued in compliance with NEMA.
Just one question, for the reference to section 63 of ICMA. You have the section with you. It's at page 765 in your colleague's bundle, 765.
I've got ICMA with me. It's not pertinent, but I've got section 63 in front of me.
Alright, so it reads, it starts by saying, where an environmental authorization in terms of NEMA is required for coastal activities, the competent authority must take into account all relevant factors, including an emphasis to set out factors which are relevant as far as ICMA is concerned. So it's not a situation where these are special factors or factors to be given special weight. These are factors that must be included in coming to the decision, must be included with the assessment of all other relevant factors which may be referred to 24.0 of NEMA. Would that be correct?
That I think it's section 5, which says that NEMA and ICMA must be read together.
Yes.
That was the court has referred to that this morning. Then I referred the court to section 6, which said that insofar as there's a conflict that ICMA takes precedence.
But there's no conflict.
No, the two, it's for the purposes of this case, the two can be read together quite comfortably.
Right. Then if you go to 63.1H7, one of the factors that must be considered is whether the activity, I'm just reading activity, there's development, but it's not a case about development, whether the activity would be contrary to the interests of the whole community. So it's only where it's contrary to the interests of everyone that you can't go ahead. You've got to have regard for everyone, not the sector of the community. You've got to have regard for all the community, and the minister, we've been referred to the extract of the minister says that whole community. And it can only be a reference to whole community economic, because there's no reference to whole community NEMA, I think. So whole community must be a reference to ICMA, and the minister says, well, in that regard, the whole community, I think, I would have regard for includes the fishers, the conservation groups, the mining companies, the broader users of the coastal, the sea, the coast, and so on and so on. So it's only where it's against, it says whole community, not against a sector of the community, against whole community. So it's a balancing, if on balance, there's one sector that may be affected, but it's only affected marginally. What then?
Can I refer the court to the definition of interests of the whole community that's in the definitions? I think it's section 1.
The collective interests of the community by prioritizing collective interests in coastal public property of all persons living in the Republic over the interests of a particular group, and adopting a long-term perspective that takes into account the interests of future generations.
So that the priority is given to the interests of the general public over the interests of a particular sector or grouping within society. So one is taking a long-term perspective, the interests of future generations, which is also a reference in inheriting coastal public property. I referred the court to that provision. So that is in the integrity of the coastal public property being passed on to the next generation and the generation after that.
The only aspect in which those interests would be affected would be if there was an oil spill. Otherwise, if a well is sunk 200 kilometers offshore, on these papers, there's no evidence of any damage to any marine life, any fisheries. As I recall, no one has said anything about that. It's not a case like the sustaining wildlife where they were going to do sonic booms into the water and were going to kill or harm or damage marine life.
My lord, I'm on uncertain footing, but as I understand the position, and I say this with some diffidence because I'm not certain that I'm correct, but as I understand, exploration activity might also entail seismic surveys in addition to the drilling of wells.
Well, the applicant's case, the appealant's case, isn't that? Maybe so, but I've heard nothing about that, nothing in the papers about that. So the only effect on long-term generation or current generation, negative, is the potential oil spill.
No, Lord, if one has regard to the climate change impacts,
Then you're going to production. That's why I asked you earlier.
well, that's for need and desirability
But that's
purposes.
what I asked you earlier on 63.1c. Are we talking about activity pertaining to exploration? And you said yes. Now it seems you want to say no, but it also includes production activity.
My lord, my submission in that regard is that the activity or development that I had initially didn't have regard to the wording of the provision there, and it might be that Section 63 requires a broader consideration than the NEMA production activities assessment. But that's not something that I'm able to present to a developed argument to the court in respect of.
Is that your reply, Mr.?
Indeed, thank you, my lady.
Thank you so much. I would like to thank everybody for the enlightening submissions that were put before this court. We'll take time to prepare the judgment and deliver it in due course. Thank you so much. Happens.
Thanks again. Well done.
You're going to pitch to